Welcome to Planning for Protection.
Welcome back to Planning for Protection with attorney Jeff Ryder. Jeff is an elder law and estate planning attorney serving families and aging adults across Carroll County and the surrounding Indiana communities. I'm Evan Mack, and today we're talking about what everyone in Indiana needs to know about asset protection. Hello, Jeff. How are you?
I'm well, Evan. Nice to talk with you.
Nice to talk with you as well. Jeff, we hear the term asset protection thrown around a lot, but what does it actually mean? Is it just a fancy way of saying keeping your stuff from people who might try to take it?
Well, I guess you could think of it that way, but it's really for people who have got assets that they want to protect from. And the big one that I see a lot is the potential for a future long-term care stay. In my area in Indiana, that can range anywhere from $7,500 to $14,000 or higher in cases. And so it doesn't take very many months to deplete one's assets very quickly. And those people who are thinking about the possibility of that are sometimes interested in doing some planning to try to protect those assets from that eventuality.
So, but Jeff, there's a myth that you need to be like a millionaire to take care of all this kind of things. For a typical Indiana family with a home, 2 cars, and a modest savings account, why is asset protection just an important for them as anybody that has money?
You know, it's very interesting, Evan, you bring that point up, because I have met with multimillionaires and I have met with people whose basically their only real asset is their home. And it's maybe even a modest home worth maybe $100,000. And so the question the interesting thing I observe is the millionaire is worried about protecting his millions. The single lady or man in their maybe 80s is worried about protecting their main asset. And if they've got 3 or 4 kids, that's just as important, it seems, for them to protect their home as it is for the millionaire to protect his millions. And so I see a lot of commonality in the way that people think about this. And if they have a choice between seeing everything that they've worked all their lives for and eventually go to the nursing home and or to the state of Indiana and in the form of asset recovery under the Medicaid program, then the choices between seeing that happen or passing it on to their family, they almost always choose to rather pass it on to their family. And there are some different ways to do that, but one of the chief ways is with an asset protection trust. There's several features of these trusts that make them pretty attractive, but there's one big drawback.
Yeah, Jeff, so some people worry that, asset protection sounds like hiding money or maybe avoiding taxes. Can you explain the difference between the illegal tax evasion and the perfectly legal strategies you use to build a financial fortress around someone's estate?
You know, I often tell a fictitious scenario to my clients. One, we'll talk about 2 people, Farmer Smith and Farmer Brown. And they live on the same road. Their farms are right next to each other. They each have 100 acres. They both work off the farm at the same factory in town in the same department, doing the same thing. And so they're both married. They both have 3 kids, and they're all the same from outward appearances, except Farmer Smith is a very virtuous guy. He is frugal. He works hard. He doesn't waste a penny. He makes everything stretch. He's one man woman. He raises his kids right. He does everything right. The other guy is kind of the opposite. He's got every vice known to man. He drinks, gambles, runs around. He has an addiction. He is not good with money at all. He blows every cent he ever made. And so they're both at the factory this day. They both have a stroke at the same time. The ambulance comes and takes them both away to the same hospital. And the first guy, they both end up having to go to a nursing home. The first guy has got nothing in the bank because he's blown every cent. The other guy's got $500,000 in the bank plus his farm. So the first guy, because real estate, if it's occupied by your community spouse and is rented, is an exempt resource for eligibility purposes for Medicaid. So the wastrel guy, he applies for Medicaid and he is approved the first day that he applies. The other guy gets turned down cold. You got too much money. We're not going to approve you.
Mm.
And so, is that fair? They both worked hard. They both, paid taxes all their lives, and this is a benefit. What? Why is the one guy eligible day one, and the other guy, who's in arguably led a much more virtuous life, going to have to spend his $500,000 before he can apply for and get any Medicaid benefit?
Mm.
Uh, so if the things that we are offering are legal and they're not unethical and they're blessed by the state, every day, I don't think it's unethical for people to take advantage of the laws that are existing. And I try very hard to stay very much on the right side of the law and not do anything that would be illegal or unethical. On the other hand, I feel it is important to give people the options
Mm.
that they can have to protect what they worked so hard for.
Mm. With new privacy and consumer protection laws that take effect this year, what are the most common ways a standard estate plan fails an asset protection stress test in 2026, Jeff?
Well, I'm not, Evan, especially up on the newest privacy laws, but I can tell you in Indiana, if you have an estate when you die, uh, and you've been in the nursing home and on Medicaid, the state of Indiana has a priority claim against your estate.
Mm.
And they can come after anything that is in your estate, even certain non probate transfers. And so some people say, well, I've got a trust. I've got a revocable trust I created, 10 years ago. That'll protect me, right? Well, I have to tell them, sadly, no. Those assets that were transferred out of the probate estate after 2002 are going to be subject to estate recovery. So the only real way, well, there's two main ways to avoid estate recovery, and that is with an irrevocable asset protection trust and or a remainder interest. But there's advantages to each method, and so the irrevocable asset protection trust is the most encompassing one. But there is the small drawback with that you
Mm.
do have to give up some measure of control over the assets. And so that is a scary thing, and I don't recommend that lightly. But I can tell you, I feel like I have really the most best clients in the entire world, and many of them have very close and loving families. And so, if you have at least one child with a very good heart and a very loving attitude towards you and a very stable life and no addictions or divorce pendings, no divorces pending, it may be not that risky to let one of that very stable child be the trustee of the trust, and that gives you a lot of a lot of comfort knowing that if something comes along that is a drastic change of circumstances, that child's going to do what they can, and there are a lot of things they can do to have those assets be able to be returned eventually to you, with the idea that there is going to be a plan B, which is the traditional Medicaid planning, where we transfer assets to the community spouse and or do a spend down to get at least half of the assets generally to the family as a way to avoid seeing everything go to the nursing home.
Mm. Yeah, but Jeff, for Indiana residents with rental properties, when is it better to use an LLC for liability protection, and when should those properties be moved into specialized trusts for long-term estate protection?
Well, that's a very good question. I am also a part-time property manager, and I see uh, a lot of landlords and a lot of tenants. And I can say I'm very blessed so far, and knocking on wood, we have not had a litigation situation that resulted in any litigation situation other than maybe evicting a couple of tenants over the last 25 years. But if you have very many rental properties, I think it makes sense to consider creating an LLC to hold the title to those properties, because there is liability out there. And while you should have insurance, and no doubt do have insurance, it's never belt and suspenders. I've heard this saying. It's just an added layer of protection, whereby if there is a claim against you as a landlord of that property, the recovery, if any, of a suit would be limited to the assets that are in that LLC. So then, say you get this, one or more LLCs holding these rental properties, but you see that, boy, my health is looking like it could decline at some point. You need to think about that 5 years before you need any kind of care that you may want to apply for Medicaid for, because of the 5-year look back period. And so I've seen many people transfer sometimes significant assets through their LLC into these asset protection trusts. And that's fairly simply done, because we don't have to do a new deed. We can just transfer the membership interests of the LLC into the asset protection trust. And if the family's on board and they say, obviously we want mom and dad to continue to be considered the owner of these assets for tax purposes, especially federal estate tax purposes, then we can design these trusts as grantor trusts, which allow for an adjustment in basis up to the fair market value on date of death. There's some issues with regard to inside and outside basis with regard to LLC units, but it's always good to have the highest basis you can as a beneficiary, because one or maybe more will eventually want to sell their interest. And having a high basis means you'll obviously pay a lot less capital gains tax than you might if you did not have that adjusted basis.
Mm. For doctors, small business owners, or engineers in Indiana, how can an asset protection plan be structured to ensure a professional malpractice claim doesn't wipe out their family's personal inheritance?
If the doctor is no longer considered the owner and is not entitled to the principal of the trust, then if there is a judgment against that person, it would be limited to assets held personally, not in the trust. So it's a way to gain some protection for these kind of individuals with potential liability and perhaps significant assets.
Hmm. A common fear, Jeff, is that, protecting an asset means I can no longer use it. If I put my Indiana home or bank account into a protective trust, do I lose the ability to live in my house or spend my money?
Very good question, Evan. And the answer is yes and no.
Hmm.
One of the features we almost always build into these trusts is, if there is a residence in the trust, the grantor, the parent that's creating the trust, would have a continued right to continue to live in that residence as long as they want to. And so, as to the residents, yet no, they can continue to utilize that just as they always have. They would also still qualify for the Indiana homestead deduction, which helps reduce their real estate taxes each year. And if the trust decides to sell the home later on, because maybe one spouse has died and the other spouse has decided to move into town or move into a condo or move into assisted living, the uh, the sale of the residence can still qualify for the exclusion of gain of up to $250,000 for a single person or $500,000 for a married couple. And that exclusion of gain from the tax return, of course, is a very valuable benefit that you don't give up if you do put this residence into the trust.
Hmm.
Um, as to the cash, if you put cash into the trust, unfortunately, you do give up the ability to go to the bank and take that money out.
Wow.
Only the trustee can do that, and they can only distribute assets to uh, one of the children who is the principal beneficiary. And by definition, the terms of the trust say the parents are not principal beneficiaries. So I don't recommend people put all their cash into a trust like this. In fact, they should keep out whatever amount or whatever percentage of their assets they feel like this is money that we should have to do whatever we want to do with. If we need to travel, if we want to buy a new car, if we want to get the roof put back on, a new furnace, whatever, you do not want to be needing money all the time from the trust, because if you are, it defeats the purpose of having created the trust. So you can get the income from the trust, any dividends, interest, or rent that would be payable from the assets in the trust as the parent, but you cannot get the principal. So don't put all your assets in here. Only put the amount that you think, with any reasonable expectation, this is money we're not going to get spent during our lifetime, and we would like to pass it on to our family. So we will put these assets or this amount of money into the trust, but keep this other part back for our daily needs and our occasional splurges.
And Jeff, does a person need a multi-million-dollar net worth to justify the cost of an Indiana asset protection plan, or is this something a middle-class family should consider to protect their primary residence?
Well, it's everybody's circumstances are unique, and there is a cheaper option to protect the house, and that is a transfer of, say, the house to the children with the reservation of a life estate. Under current Indiana law, that also protects the property from estate recovery by Medicaid if you end up in a nursing home for any period of time on Medicaid. And so that is a cheaper option. The one drawback, or a drawback of that, is if there is a creditor issue with the child, it can impact the parent and his use and enjoyment of the house. And for illustration, I had a client one time who put her farm, including the farmhouse, into a life estate. She had two children, and one child was, very solid. The other child was married to a person that wasn't a good money manager. And they eventually came to mom and said, my spouse is telling me we're going to have to likely file for bankruptcy. You should talk to your lawyer and see if the land's going to be okay. Well, initially I thought, well, yeah, because the life estate is is a major portion of the value of the property, and it's not likely that the creditor would pursue that. But I happened to be working with an experienced bankruptcy attorney at the time, and I asked him, and he said, Jeff, you are wrong. The bankruptcy trustee for that child can force the sale of the entire property as part of the administration of the bankruptcy. And of course, the parent would get a large portion of the value on the sale, and the sibling would get half of what's left. But the bankruptcy trustee could take the half that was the child that was in bankruptcy's share of it. And so that, of course, was not something she wanted to hear very bad. In fact, she was pretty devastated. But thankfully, at least at the current time, the child has not had to file bankruptcy, and they've been able to put off that eventuality. And I hope she never does have to experience that. Wow. So that's the drawback of doing the life estate, or a drawback of doing a life estate. And the other thing is that life estate only applies to real estate. It doesn't apply to cash or other assets, whereas the trust can handle both cash and other assets besides real estate. But it also can handle real estate, and it does put a little bit of a wall and a layer of protection around the assets if there is a issue with a creditor of one of the children who is a beneficiary of the trust.
Jeff, thank you so much for your time, sir.
You're very welcome, Evan. It's a pleasure.
Pleasure's all mine. That's it for today's episode of Planning for Protection. If you'd like to learn more about attorney Jeffrey Ryder and his work at Jeffrey C. Ryder, Attorney at Law, LLC, visit jryderlaw.com. Thanks for listening, and don't forget to like, subscribe to the show, and share this episode with someone who might find it helpful. Thank you so much, and we'll see you next time.
Thanks, Evan. Bye-bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.